Okay.
Because he's told me the only reason why his parents put him out of the home is because he was looking for employment and he couldn't find employment. I just find that hard to believe that a parent would do that. You would not allow him to continue to reside at your home, is that correct?
Yes, ma'am.
And can you tell me the reason for that?
The reason for that was because he was just not following the rules at home. He was making it difficult.
The revocation hammer. Hold up. 6 years, just like that. This defendant was clearly on probation or deferred adjudication, and the judge just revoked it. When a judge finds you've violated the terms, especially when you've been missing for well over a year, all that time you saved is gone. The original sentence, which was likely suspended, just came crashing down. That is a high price for missing an appointment.
For us,
The court is going to revoke. Where have you been since 2021? So I don't think you're a good candidate for probation, and I'm not going to continue you for you to be continued when you've been missing for well over a year. The court will find you guilty of revoke. The court will sentence you to 6 years in the prison.
One date and nothing else after that. And now I'm being sued for $10,000. There was
Exactly. And I got documents that prove he was lying.
You don't understand. What? It's a false
He put
statement
a
made
document.
under
He
oath.
placed a
Under
document.
oath. When did he testify to something that he lied about?
All right. Did you understand in the cause number ending in 7W, the state is proceeding on the lesser included offense of assault causing bodily injury family. That is a Class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Do you understand? All right. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find.
Legal Lifeline explained Scales hash. Okay, now we've moved to a new case involving assault causing bodily injury family. The defense is asking for deferred adjudication, that's their lifeline. This is essentially a second chance where the defendant pleads guilty but the judge defers the official guilt finding. If he completes his probation, the case is dismissed and he avoids a conviction. But wait, the attorney mentions the victim is pregnant and they're expecting a child together. This is a massive emotional and legal pressure cooker.
Are you guilty? The court will defer finding of guilt as you applied for deferred adjudication in each cause number. Counsel, are we proceeding with sentencing?
Yes, Judge, and if I may say a few words on Mr. Newman's behalf, respectfully, we ask the court to follow the plea bargain above the line. With respect to the items recommended by the state below the line, Judge, we recommend that the court place a condition where Mr. Newman has no harmful and injurious contact with the alleged victim. I believe that is her wishes, the victim, that is to say, and they are expecting the child together in the very coming months, near months. In addition, Mr. Newman is, he was at the time, Judge, been battling some homelessness. He's informed me that he has been allowed to come back into his home with his parents. And he's, currently trying to work through getting employment. He's a young man, like I indicated, just turned 20 years old this past August, I believe.
so
And that's what I have to say on behalf of Mr. Newman.
Right. And why are you not living with your parents?
He is now, Your Honor. He was not.
Okay, why were you not living with your parents before?
They didn't want me at home
Why not?
because of my inconvenience, because of my attitude.
Right. What was the issue with your attitude?
Anger, disrupting the environment at home.
Why were you doing that?
I felt stuck. I was trapped. Couldn't do nothing and get out.
What were you trying to get out of?
I was trying to find work, trying to get up on my feet, and I just couldn't.
Well, how far did you go in school?
I got to my freshman, sophomore year, and I got homeschooled.
Sophomore year, freshman year of what? High school?
High school.
All right. So,
And then
and you say you were homeschooled. So why didn't you complete high school?
I graduated,
All right. So you graduated from high school.
but I did it through homeschool.
Right. So you graduated from high school.
The attitude red flag, triangular flag on post. Did you catch that? The judge is grilling him, linking his current problems, the homelessness, the lack of employment, the assault, back to his past behavior. He's saying his parents pulled him out of school because he was too bad. This isn't just about finding a job. The court sees a pattern of anger, defiance, and an inability to follow rules. They're building a psychological profile to determine if probation is even possible. Do you think his history should count against his chances here? Let us know in the comments.
Through homeschool. So did you start going to school and then were homeschooled?
Yes.
Why?
They felt that I was being too bad.
Was they?
My parents.
All right. So they took you out of school to be homeschooled.
Yes.
So you have your, I guess, your high school degree. And you can't get employment. Why couldn't you get employment?
People were just weren't hiring at the time.
Where did you look for employment?
All over.
No, where is that?
Like fast food industries, construction. I looked in retail.
So you didn't think maybe you needed to increase your level of education or go to a trade school?
I thought about that as well.
But
I
did you
haven't
do it?
further proceed, no.
All right. And then the person, the complainant in this case, in the police report, what I read is that
The pregnancy and alcohol bomb. This is a dramatic, tragic reveal. The victim is pregnant with his child, and the police report states they were drinking together downtown, and she was trying to get him a hotel room because she was homeless but wanted him to have a place to stay. Wait, the victim is homeless but trying to pay for his hotel? This flips the entire narrative of who the aggressor and who the victim is in the relationship, or at least shows a deep, troubled dynamic. The judge is clearly trying to piece together why this assault happened.
she told you she was pregnant, and then both of you were drinking downtown. What were you drinking downtown? Alcohol?
Drinking downtown.
No, this is what it says in the stipulations. It says, victim stated that she was in a dating relationship that was on and off with the suspect, that's you. And they were trying to work things out because victim is pregnant and she made you aware of the pregnancy. Victim stated that she and S1 have been driving and drinking all day and she wanted to go home. It says that victim is homeless but wanted you to have a place to stay. So, and she tried to, well, she wanted you to have a hotel room and she tried to drop you off, but you didn't want to be dropped off. What's that about?
That
The fact that she tried to buy a hotel, well,
Yeah,
sorry, she tried to get a hotel room for you and to drop you off, but you didn't want to stay.
no, it wasn't that I didn't want to stay. We were there at the vicinity when everything happened. And from being downtown, we never drunk.
All right, so
Or
then,
was downtown.
okay. So then the hotel that she obtained for you, why do you want to stay there if you were homeless?
I was trying to stay there.
Then I don't understand, how does this go from you being homeless, she's trying to get you a place to stay, and then you're hitting her?
She didn't want to get it for me because of someone else that was with me. And I told her that that person wasn't going to be there. It was just a ride. I was just a ride.
Was it a girl?
And then she proceeded to strike me while I was driving. So I stopped the car. And I didn't retaliate in hitting at first. I just poured her drink out. It was just Sunny D.
And whose car were you driving?
Driving hers.
All right. And cause number 2025 CR 001217W. The court is going to sentence you to 1 year's deferred adjudication. There's to be no contact with Shayla Mills. Y'all are going to have to do child custody through a third person. And counsel, if she wants to have contact with him, she'll need to come in and speak to the court.
Oh, I understand, Judge.
There's to be 80 hours of community service restitution. I'm going to order parenting classes. Once you, I'm sorry, not 80 hours. I'm going to order 100 hours of community service restitution. I'm going to order parenting classes. Once you've completed parenting classes, 50 hours of the community service will be deemed satisfied. And then the remaining 50 hours will be satisfied if you obtain any type of trade school certification or you complete a higher level education. Otherwise, you can just do the 50 hours of community service and they're going to have you picking up trash somewhere. You understand?
Yes, Your Honor.
There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider with minors. There's an affirmative finding of family violence. This will run concurrent with 2024 CR 02811. There's to be the BIPP course and field visits one time per month for 6 months. And cause number 2024 CR 012811, the court will sentence you to 3 years deferred adjudication. This will run concurrent with 2025 CR 001217W. And counsel, I'm also going to put in the 2024 PF 18961 case in case there's some confusion in the system.
Judge, I would just say, with respect to the bib class, do you want him to take a bib course in addition to try to get a job and get some training?
Yes,
I think that's going to be, he's not going to be able to do it.
sure he will. And there's going to be 3 years deferred adjudication. The cases will run concurrent. There's to be restitution and no contact with Academy. And the restitution amount is $629.99. Again, there's regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits one time per month for 6 months. There'll be 100 hours of community service restitution. And the same, if he completes parenting, 50 hours will be deemed satisfied. And the other 50 hours will be deemed satisfied if he obtains a higher level education or completes some sort of trade school. All right, we can go off the record to be successful on probation in this court. Communication is key. If there's an issue, let probation know. If you feel as they're not addressing it, you can always come back to the court. All right, good luck to you. Thank you for dressing appropriately for court.
Thank you.
Thank you.
Have a good one. Thank you.
You too.
Yeah, thank you. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2024 CR 012811 for the offense of theft of a firearm on February 4th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
Judge, really quick, there were two.
There too.
Yes, so there's the one, the theft firearm, and then there's cause number ending in 001217W. That's a family violence.
All right. And then we're also proceeding then on 2025 CR 001217W.
Okay. And
just one moment. And that cause number, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2025 CR 001217W for the offense of assault, bodily injury, family, household on February 4th, 2025 for a period of 1 year? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
we will be proceeding on the same violation in each cause number, and that's violation of condition number 4. In Bexar County, Texas, the defendant Dalen Newman did then and there fail to report to the supervision officer as directed for the months of March, April, and May of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
State, do you waive the other?
The remaining.
No objection, Your Honor.
All right, in cause number 2025 CR 001217W, did you understand by pleading true to violation of condition number 4, the court could find it true grant the motion, sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine?
Yep.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true, and in cause number 2024 CR 012811, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Be true.
Yes, court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. And just so the court is aware, this is the defendant's first MTR, and he was placed on deferred education in each cause on February 4th of 2025. And so the agreement for the court's consideration is to deny the state's motion, continue the defendant, but alter and amend his conditions to include a TAP evaluation to be done in custody, weekly reporting for 60 days upon release, the moral recognition therapy course, and a 30-day jail sanction to run concurrent with the days that he's in custody awaiting the TAP evaluation.
All right.
That was our understanding.
All right. Do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record.
Dalen Newman.
Why are you not recording?
I was going down the wrong path. I was kicked out and I was homeless and I couldn't
Kicked
have
out from where?
my household.
And who's in that household?
My mom, my little brother, and my stepfather.
So why did they want you out?
Because I wasn't able to find a job in the time that I needed to.
Why were you not looking for a job?
I was looking, but I wasn't applied to or recognized in the time that I was needing to be recognized for work.
All right, so here's the thing, and you correct me if I'm wrong. Usually parents love their children, and if they're doing everything they can to find employment, normally they won't kick them out of the home. So what else was going on in the home?
There was nothing else going on in the home, Your Honor.
So you're telling me if your parents were to testify, they're going to say, we just put him out because he didn't obtain employment, that he was doing his best. He was going out every day trying to find employment, but he just couldn't do it. So we kicked him out because no one would hire him. You're telling me that's what your parents are going to say?
Yes, Your Honor.
All right. Then let's have the parents testify to tell me what was going on in the household. I want to know. Because I find it very strange that parents would put somebody out, a child who's doing the best they can, going out, seeking employment, and then they would put them out because they're unable to find employment. So.
Yeah, I do not believe that his parents are present today to testify.
Oh, I mean, we can always recall this back. We can recall this back for Thursday. And if there's no objection, his parents can appear by Zoom.
Yeah, I believe that Mr. Newman has relayed to me. I believe that his parents are going to allow him back into the home.
Oh, no. I want to know why they put him out of the home. Because if you have parents who put a child out of the home who is doing his best, seeking employment, and I find it just strange that that's the only reason why they would put him out. So I want to know if that's the only reason why they put him out.
Understood, Your Honor.
And they'll be placed under oath if they appear. And then the court will hear that. So we can recall it for Thursday for your parents to appear so that they can tell me under oath why they put you out of the home.
May I have a brief sidebar with my client judge?
Sure.
Before we proceed? After conferring with my client judge, he expressed to me that part of the reason is that he was not allowed in the home anymore.
Well, I mean, I want to hear from him.
Okay.
Because he's told me the only reason why his parents put him out of the home is because he was looking for employment and he couldn't find employment. I just find that hard to believe that a parent would do that if somebody is doing what they're supposed to be.
Mr. Newman, do you want to explain to the court what you just expressed to me?
Yes, sir. I said that I wasn't meeting their obligation as in finding a job in time, as I failed to meet y'all's obligation in the 30 days.
What else did you tell me about probation?
Probation, that they said that I was failing to attempt to pursue my probation as in checking in.
Well, no, I mean, you're still saying the same thing. You're adding, but you're still saying the same thing. You're saying that the only reason your parents kicked you out of your home with them is because you could not find employment. That's what you're telling me. That's what I'm hearing. If I'm hearing something different, let me know.
You're not.
All right. So you can have the parents here by Zoom and the reason why I'm doing this is because maybe that's not the right placement for you to be at home with his parents if they're putting him out because he can't find employment and he's doing everything else perfectly. So they can appear by Zoom.
All right, Judge, I just do not have any contact information for his parents.
Oh.
I will talk to Mr. Newman,
All right.
see if I can get some available. However, I do understand as well that in the court summary, it did state that the parents were, I don't know if they were available to be contacted.
All right. Well, he should have their contact information to see if he's been living with them. All right.
Right, Judge.
All right. Thank you.
Your call to roll for Mr. Newman, Your Honor.
All right. And we have a
Parental truth bomb explosion symbol, and here it is. The moment the judge forced the truth out. The mother, under oath, directly contradicts her son. She didn't kick him out just because he couldn't find a job. It was because he wasn't following the rules, making things difficult, not dressing properly for interviews, and having certain people over. The son lied to the court, and now he's paying the price with his credibility. This is why you never lie to a judge, it always comes back to bite you.
witness by Zoom. Are you Lisa Newman?
Yes, ma'am.
Can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Ms. Newman, there was testimony taken in this case that you put your son, Dalen Newman, you would not allow him to continue to reside at your home. Is that correct?
Yes, ma'am.
And can you tell me the court the reason for that?
The reason for that was because he was just not following the rules at home. He was making it difficult for us. And we told him that if he couldn't follow the rules, that he would need to be on his own. And he decided that he didn't want to follow the rules and he wanted to be on his own. When we told him when he was ready to come back home and do what he needed to do to get himself right and back together, go to school, finish up his classes that we planned on him doing, his parenting classes, his other stuff that he needed to do that you had asked him to do, that we would be there to support him and help him out with all of that. So, and by him being in jail, he's noticing that it's not easy out there without having support and family.
All right. And so what rules was he not following?
Finding a job was one. He was looking for jobs. He was putting in for jobs, but I don't see that he was complying of going to the interviews. If he was going to the interviews, he wasn't dressed properly to go to the interviews. We would ask him to do certain things around the house, not having certain people over and things like that.
Okay. All right. Thank you so much for letting me know what was going on.
You're welcome.
Okay. Any other questions?
Nothing further from the defense, Your Honor.
All right. And I'm sorry, State, what was your recommendation?
Okay, Your Honor. We were asking for CAP, weekly reporting for 60 days, MRT, and a 30-day jail solution.
Oh,
That's
this is
understanding, Your Honor.
this is what the court is going to do. In cause number 2025 CR 001217W, the court is going to revoke, find you guilty. The court is going to sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Shayla Mills All right, and that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, do you have a limited right to appeal? That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And cause number 2024 CR 012811. Court is going to give you a choice. And the
Prison or treatment. Person with praying hands. The judge gives the second defendant, Mr. Webb, a final choice. 2 years in state prison or be continued on probation but with mandatory ISF and in custody substance facility. This is a critical moment. The judge is showing some mercy, recognizing his extensive drug history, and offering treatment instead of immediate hard time. He's making it clear, I don't think you're a good candidate for probation, but I'll give you a highly structured, treatment-focused chance if you take it. Do you think this is a fair trade-off for his criminal history?
reason why you're getting this choice is because you still owe restitution. One, I can revoke you, and if I revoke you, I will sentence you to 2 years in the prison, or I will continue you and you're going to ISF.
Could you explain what ISF is to me, please?
Oh, it's a facility and it's while you're in custody, and that is to help you get your mental state in focus. So, do you want prison for 2 years or do you want to be continued with ISF?
I'll continue with the ISF.
All right, the court will deny the motion, alter and amend conditions to include the following. There should be a tap in custody, follow recommendations, and ISF. Probation, is there anything else?
Judge, I just want to confirm, we don't have any restitution listed for that.
They have a restitution amount of $629.99 to Academy.
I'll look into that, Judge. And then, is this to be implemented after the 365?
Yes. And the cause number ending in 9819, you're charged with fraudulent use or possession of identifying information, 50 plus items. That's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And the cause number ending in 0549, you're charged with the offense of possession of a controlled substance. Penalty group 1 gram to 4 grams. That's a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right. So guys, everyone, when you have somebody who's in the box, please don't talk behind the court reporter. Just ask and they'll take you to the other end. And the cause number ending in 0549, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right. State any evidence.
The cause numbers stated number 1 with all its factors.
Any objection?
No, Your Honor, I've reviewed with my client. We have no objection on both cases.
All right. All right. And each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Ms. Ferguson, I need a date, return date for PSI and TAP. All right. We're going to come back on January 25th. On January 25th, I will let you know whether or not I'm going to grant your application. That decision will be based upon the PSI report and any of the evidence that's submitted to me. Do you understand?
Yes, ma'am.
All right. So if you make sure you make all of your appointments, and if you will get a reset form, you're excused, and then you'll need to speak with probation.
Okay.
All right. Thank you. Hey, Webb.
That's me, Your Honor.
Yes. Where's Mr. Webb?
Mr. Webb is broken down on the side of the highway on the other side of Schulenburg.
All right.
We can put a warrant out and bring him in tomorrow, or we can just recall it for tomorrow or whatever.
There'll be a warrant out for him, and I think the bondsman has filed an off bond. You're the bondsman?
I believe so. I
All
wouldn't
right.
swear to it, but
Okay. All right. Court is calling 2023 CR 9819 and 2023 CR 0549, State of Texas versus Johnny Joe Webb. Can I have parties announced for the record for the state?
Daniel S. Clark for the state of Texas.
Defense?
Not ready, Your Honor.
All right, and who's for the defense?
Matt Stolhansky, I apologize.
All right, this hearing was scheduled at 9 a.m. It's now 10:33 a.m. Where's your client?
My client is broken down on the highway.
All right. So, he was supposed to be here. He's not here.
Yes, ma'am.
State?
David asked for a bond forfeiture.
All right. It's my understanding that the bondsman on this case, defense counsel believes he's the bondsman, but a bondsman came in and electronically filed an off bond on this case. So if that's the case, the court is going to sign it. If it's not the case, then a bond forfeiture will be granted. All right. Is there anything else?
No, ma'am.
All right. Thank you.
So should I bring him in tomorrow?
Oh, yeah. I mean, well, there's going to be a warrant out for him.
Can we take care of it tomorrow if I bring him in? Or do we
Yes.
Okay, perfect. Thank you.
And can you? All right. And who is on Johnny Joe Webb? Come forward. Come forward.
Little people are in my way.
Okay. And is he pleading on both of these cases?
We've already pled, Your Honor. This is the sentencing.
Ah, okay. Thank you.
You need a PSI?
No, I have the PSI.
Okay. Yes.
All right. Court is calling 2023 CR 9819 and 2023 CR 0549, State of Texas versus Johnny Joe Webb. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Matt Stolhansky for Mr. Webb.
All right, Mr. Webb, you entered a plea in the cause number ending in 19 to count one of guilty, and you entered a plea in the cause number ending in 49 of guilty. And each cause number, the court found there was sufficient evidence to find you guilty, and the court found you guilty. And the cause number ending in 49, the state is silent on your application. They're asking that your punishment be assessed at 6 years. And in cause number ending in 19, the state is silent on your application, and they're asking that your punishment be at 6 years. Have both parties had a chance to review the PSI report?
Yes, sir. Yes, Your Honor.
Any objections to the PSI report?
No, ma'am.
All right. Any witnesses defense?
No, ma'am.
All right, then the court will hear argument.
Your Honor, if you look at the PSI, you can see he has quite an extensive criminal history, but he's never got any drug treatment, and he's been using since he was a preteen. He was been using alcohol, drugs, things like that. He's been in the precision recovery for quite a while. The PSI suggested that if he gets probation, that DDF would be a good place to put him. He's got some mental issues as well. We're asking that you give him probation, and like we've sent him to jail several times. That hadn't helped. We need drug help.
All right.
Oh, and he apologized for not being here yesterday.
Okay.
He's here today as promised.
All right. Mr. Webb.
Yes, ma'am.
I am reviewing the PSI report, and there's a lot of criminal history here, but you have a theft, possession cases, and then this case is fraudulent possession of identifying information 50 or more.
Yes, ma'am.
And then as a part of this plea bargain agreement, the state took several cause numbers into consideration.
Yes, ma'am.
I just don't think you're a good candidate for probation. I will ask for the therapeutic community for you, but I'm not going to grant you probation. And cause number 2023 CR 9819, the court has previously stated is finding you guilty. Court will sentence you to 5 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money will run concurrent. Take in consideration NITMAG number 734693, 2023 CR 9820, 2023 CR 0220. And with regards to restitution, probation, were there any complainants that reached out with the restitution amount? I'm looking, I don't see it. It says to be determined. For each complainant, I have to be determined. All right, so there'll be restitution if any. And this is to run concurrent with 2023 CR 0549, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, and I'll recommend the therapeutic community. And cause number 2023 CR 0549. Court is finding you guilty. The court will sentence you to 5 years in the prison. Give you credit for any time served. This will run concurrent with 2023 CR 2023 CR 9819. There's a $1,500 fine. Time and money will run concurrent. Take in consideration NIGHTMAG number 734693, 2023 CR 9820, 2023 CR 0220. And there's to be restitution to SAPD for drug testing. And the court will request the therapeutic community. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Your Honor.
Yes.
Mr. Webb had requested that he be allowed to turn himself in at a later date.
All right.
I have to take care of my grandma.
The TIC on the mission.
All right, that'll be denied.
Sure. Can you speak?
Yes.
I take care of my 87-year-old grandma, and we were thinking that I was going to get probation because of or DDRF, and so I haven't been able to find anybody to take care of her, or help me take care of her. So I just need like a week to get it situated, and I'll turn myself in. I don't have a problem doing that.
All right, I'm sorry, that'll be denied.
Yes, ma'am. Okay.
All right, are the parties here on Ricardo Juarez Ramirez?
Ready, Your Honor?
Martinez?
Yes, ma'am.
All right, a bond forfeiture was entered because you did not show for court on December 10th, 2021. I'm sorry, yes, 2021. So where has your client been?
In San Antonio.
All right. So what are you all stating for a bond?
We agreed to a $2,000 bond, Your Honor.
There were two cases, $2,000 in each.
All right, I only have one.
I gave.
No, I have a, so do you want to present any information about your client's ability to make bond?
Judge, he is working.
I mean, you want to call him as a witness, or are you all going to just do a proffer?
I'll just proffer.
All right, any objection to the defense doing a proffer?
No objection, Your Honor.
All right, yes.
He has a job. He was working before he was picked up. That's another matter. But the point is, he's working. He can make the bond. His girlfriend's on the outside, and she'll help him. And he needs to get back to work. That job is waiting for him.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Lee Andrew Martinez.
All right. Are you employed?
Yes, Your Honor.
Where have you been since 2021?
I've been at the same residence that is provided, 405623 Randolph Boulevard.
And what do you do for work?
I'm a car salesman.
Okay. Did you not know about this setting?
At the time that it happened, I was unaware. And when I got the information in the mail, it was past due. So I missed the court date.
All right, so where have you been for 3 years?
Been at that address.
No, I mean, with regards to this case, were you arrested? Did somebody find you? What happened?
I got arrested. That's how I'm here now.
On another matter.
When you say arrested on another matter, what is this other matter?
Family violence assault.
And who is the complainant in that?
I've talked with her, Judge.
No, what's her name?
Lizette.
Lizette what?
De La Rosa.
How do you spell the first name?
Lizette.
Last name?
Delarosa.
And what is her relationship to you?
She's my girlfriend.
And is this the person you're currently or you want to live with?
We're not living together. I live with my mother.
All right. So what's the bond on that case?
$5,000, Your Honor.
All right. So what's his criminal history?
He does have a, excuse me, Judge, I printed this out.
No problem.
He has a possession of marijuana from 2008. That's a felony.
All right. This is what the court is going to do. In each case, the court will grant a bond. Bond will be set at $6,000. In each case, there's to be no contact with Lizette De La Rosa. There's going to be partial GPS for work only. All right, Mr. Martinez, they told me you were negative. I'm happy. All right, so we're back on the record in 2021 CR 9487. The court will sentence you to 6 years deferred adjudication. There's to be no contact with Vincent Palumbo. There's a $2,000 fine that will be probated. The court has informed me that 2021 CR 9488 has already been dismissed, but just in case something happens, I will notate on the docket sheet that that's being taken in consideration.
He had a question. He's part of his conditions of pretrial was to have a monitor, GPS monitors. That's not a condition of probation, so that would be removed, correct?
Yeah, that's not part of the probation. Or...
All right. Then the court will order removal of GPS.
Thank you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, it is.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful in probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, you can always come back to this court, okay? All right, good luck to you.
Thank you.
You're welcome. Norma, on Rudy Gonzalez, are you the same Lee Andrew Martinez who was placed on deferred adjudication in 2021 CR 9487 for the offense of possession of a controlled substance, penalty group 2, 4 to 200 grams on May 2nd, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
We're going to proceed on the violations on the first amended, Your Honor. On or about the 4th day of November 2025 in Bexar County, Texas, the defendant Lee Andrew Martinez committed the offense of evading arrest in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
In Bexar County, Texas, the defendant Lee Andrew Martinez did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
And in Bexar County, Texas, the defendant Lee Andrew Martinez did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, and October 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And we'll waive the allegations in the original, given that they're out of county.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find 4 and 4 true. Is there a proposed agreement?
I guess not, Your Honor. We're recommending revocation and 6 years to do.
Judge, we'd ask that you follow the recommendation of the probation office. I don't know if you have the court summary.
No. Any objections to the court review and the court summary?
I've got it.
Warren,
I have it.
she has.
So you see their recommendation is inpatient treatment. Of course, he has some issues out of county, which are the ones that we waived. So you'd have to clear those as well. I told him he's not going to be able to deal with that here. He'll have to-
All right. Does he want to address why he didn't report? That's the easiest thing to do.
Exactly.
And it seems like he has been missing for, let me see.
About a year, then.
Yes, he's been gone for a year. So
I could.
do you want to address that?
Yes, I do.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
Lee Andrew Martinez.
Any objection to the court inquiry?
No objection.
All right, why didn't you report in July 2024?
Well, the last time I did report,
No. Why didn't you report in July of 2024?
I've just been busy with my family and work.
Why didn't you report in August of 2024?
The last time I did report, I sat there for like 3 or 4 hours, and they told me my probation officer wasn't going to see me. So I just sat there and waited, and then I ended up leaving.
So, and what month was that?
Not the first month, but
It was, I believe, June.
All right, so what that means is that you didn't report for July, August, September, October, November, December, January, February, March, April, May, June, July, August, September, October. And if you haven't reported, then what have you done? Did you take UAs with them?
I did.
Well, how did you take UAs if you didn't report?
I think I only took maybe 1 or 2.
All right. So did you complete sober support meetings?
I think just a few on the Zoom, maybe just a couple.
Did you complete your parenting classes?
No, I didn't complete parent.
All right. So basically you didn't do anything. And I don't think you're a good candidate for probation. The minimum you can do when you're on probation is report. And you didn't do it. So I don't think you're a good candidate for probation. And whether you're working or not, I don't know if that's true or not. You know why I don't know this if that's true or not? Because you didn't report. So I don't think you're a good candidate for probation, and I'm not going to continue you. And I don't know why in this case there will be a recommendation from probation for you to be continued when you've been missing for well over a year.
I think I just needed like some treatment help, and then possibly something.
I don't know if that's true. You know why I don't know if that's true or not? Because you haven't been reporting for over a year. I don't have anything to show that you've done anything.
I feel like if I did get treatment, it would help me out in society, and I would be able to possibly do better when I get out.
This is the thing. I don't know if you need treatment. And you know why? Because nobody's seen you. You've been missing. I will tell you, some people, not everyone, I don't like to say everyone, some people always need treatment when they're looking at a motion to revoke. But I don't think you're a good candidate for probation, and I'm not going to continue you. I tried, but when you disappear and you're gone for over a year, that's telling me you don't want to be on probation. So I'm finding 4 and 4 true, going to find you guilty and revoke. The state is asking for 6 years. Counsel, what are you requesting?
Judge, the underlying is for vape pens from, penalty group 2. This is not methamphetamine or heroin, is a cocaine.
Stipulations on this, please. You may continue.
And we'd ask that you consider the lower end of the range. The range is 2 to 20, somewhere the 2-3 year.
Do y'all have the stipulations?
Judge, they should be scanned into Odyssey. I'm looking it up right now.
All right, thank you.
Yes, ma'am. Judge, unfortunately, at this time, I've looked through every single page on Odyssey for stips, and it's not scanned in, Judge.
Your Honor, I'm trying to pull up the police report. I don't know if you would want to see that.
All right, any objections to the court reviewing that?
I'd like to see it first.
All right, well, it should be what's in the stipulations. There's no need to do it. I'm just going to go strictly on what's the indictment. All right, is there anything else you wish to say on behalf of your client?
No, Judge.
As previously stated, the court is finding 4 and 4 true. The court will find you guilty or revoke. The court will sentence you to 6 years in the prison. Give you credit for any time served. There's to be no residing in households with minors. There's to be a $2,000 fine. Time and money will run concurrently. Yes.
I just wanted to clarify, Your Honor. I think the new number ones where there was possibly a VPO and something else, those were out of county. And so we don't know anything about the facts of those cases. Locally, he has the assault, which that victim is from, and then an evading. So if there's a VPO, I don't know who the other victim are.
All right, thank you. All right, thank you. Good luck to you.
Did you send in your pretrial questionnaire? Yeah.
No, sir, I did not. I was in the process of moving and got it late in the mail.
And what?
I moved from North Carolina to South Carolina, and I just got it from being forwarded from my old address.
Okay, and Ms. Short, I don't, the Twitter version, I don't even understand what this is about.
I'm sorry, I had
in the background.
I'm actually at the airport, so I had to go outside. It looks like they just departed a flight. I mean, they just arrived the flight. So there's a lot of people around, so I'm trying to go where there's no traffic. But thank you. That's okay. No, I'm trying to finish this before I get finished. It's actually louder.
Okay, I'm not sure. I read your complaint again, and you have not. I'm looking here. You know, what is it? Intentional infliction of emotional distress.
Yes.
Is that the claim?
Yes, it is.
That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court.
That's an equitable action. Yes. Mm-hmm.
Okay. Was that not? I thought only criminal offenses. Oh, well, I guess it would be considered. I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before the circuit court. So will I have to? Will I have to?
What's in your head? I cannot get into what's in your head, man.
I'm sorry. I got to go back in because I can't hear you.
Mr. Jordan, let me just ask you this: are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had one date and nothing else after that, and now I'm being sued for $10,000. I don't see how this is going to go any further. I think it's a waste of your time.
Well, the problem is this. If you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what I'll do.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it, the document in front of me.
The short perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of pain, which was not. I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition of what's a crime and what isn't. If somebody gets charged with perjury, that is a criminal felony charge. You have to go through the prosecuting attorney and the police. So that's what you are alleging.
Yes, the document will show that. And I also sent forth the messages where he was lying, and it proved he was lying. I emailed that to the courts. I wasn't able to print it out, but they didn't say anything as far as me not being able to turn those documents in. But that should have been in the case file as well.
Did you put it in there?
I emailed it.
I don't see
sent
that
it.
mentioned in your complaint.
Yes, I emailed that.
Did you amend your complaint?
I didn't have to amend my complaint. I had to get an address for him, so I sent it to the only where the second known address.
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't. I don't know what you said you did, but you
No,
you
the
have to
last
amend your
time.
complaint.
No, the last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served, so I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess, after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter. And
That's
then
his answer, I guess. I guess we're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury after his response.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No. It's his version. First of all, do you understand what perjury is?
Yes, I understand what perjury is. I know what perjury means.
Perjury is a statement, a false statement made under oath. So
exactly. And I got documents that prove he was lying.
You don't understand. It's a false statement made under oath. Under oath. When did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is, you said it's a criminal offense, so I will send it to circuit court. Are we done here?
No, you don't, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury is statement made under oath.
Perjury means. Are we done
no,
here?
You don't. What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know anything.
But you're the plaintiff. Wait a minute. You are the plaintiff. You have to lay out your allegations properly.
Are we done here?
No, we're not.
Exactly what perjury means.
No, we're not.
Do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your complaint out. You have to allege this in the complaint. You have not.
Do not insult my intelligence.
It's not about that. You don't think. I don't think you understand what perjury is. It's a false statement made under oath.
Are we done here?
I said no.
Do not insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Are you going to dismiss it and refile it?
No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
you can't have two cases on the ma'am. You can't have two cases going on the same issue.
Well, I'm not dismissing the case. If you want to dismiss it, that's up to you. But as a plaintiff, am not dismissing the case.
He has to make a proper motion.
Well, that's on him.
But I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere else. So that's okay.
Okay. I'm going to do that. Give me the phone.
Yep.
Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see, because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be
I didn't say
brought.
that. That is not what I said.
Yes,
That is not what I said.
That
I
is what you
said
said.
that, sir, no, I didn't. You
Yes,
said
you
that.
did. You stated
I said that
you,
circuit,
no, no, you
I
stated
said
that the criminal, you stated that emotional infliction of emotional distress is a criminal offense. And you stated that perjury is a criminal offense. But you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint. It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that. What?
Yes, you did.
I never said that.
You did.
No, I did not. Ma'am,
Yes, you did.
listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said that intentional. You need to be quiet while I'm talking. You need to be quiet. Mute. Can you mute her, please?
Because perjury is a
Can you
criminal
please
offense
mute
that
her?
has to go to circuit court. Intentional
Well,
infliction
she's
of
got to be
emotional
muted. What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterized that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are of the mistaken belief that circuit court does not hear civil matters, because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court, because that's what you stated on the record. Unmuted.
She's been talking the entire time.
Well, I said I was muted.
Judge, excuse me, you don't understand how this works. Let me explain something to you about Zoom right quick.
Okay.
When I muted her and now I'm asking her to unmute, if she doesn't do something on her end, she's still muted. So right now she's still muted. But I have asked her to unmute. She's not looking at the device that she's holding. I don't think she heard a word I said. Because like I said, she's not looking at it to know I've asked her to unmute.
Is there a website where I can get the forms I need for this to be dismissed?
Listen, sir, let me just explain this to you. Okay? You know, there are forms on the State Court Administrative Office website, okay? But, you know, if you don't know what you're doing, if you don't know what you're filling out, you know, just flopping around like a fish on a dock on your wall. And the same goes for Ms. Short, because she apparently doesn't understand the jurisdiction of what types of cases can be done in district court and what types of cases can be done in circuit. That's why we're having this issue right now. So how can I put it? I'm trying to think of a good analogy. If two people that have no military training, amateurs, and they want to throw hand grenades, well, you know, you don't do it the right way, you might blow yourself up. You might blow the other person up, but you might blow yourself up too. And people need to, if they don't understand how the process works, I would say this to both parties, you need to seek out legal counsel. So, you know, both of you have the right to go to the State Court Administrator, Michigan SCAO website for the standardized court forms. But I don't know if they have a motion to dismiss form with checking the boxes or not. Usually attorneys draft those out and indicate why the case should be dismissed. Okay, now I muted Ms. Short because she was talking over the court and being extremely disrespectful and rude to the court and was not listening to what I was saying and really being disruptive. That's why she was muted. Now, if she is ready to listen to the ruling that I'm making here, then, you know, she can rejoin, unmute herself, and let's come on back in here And let me read this order.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Ma'am, this is what I'm
yes.
doing. I'm ordering that this go to Seventh Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees and the receiving, and I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury fee. No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what cost am I paying? Hold on. What cost am I paying for?
Filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple cases that have been brought forth.
Because you filed it in district court, we don't do intentional infliction of emotional distress cases.
Well, I need to see that in writing. I need to see that document in writing that states that
If you want to appeal, if you want to,
I've already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there that states
that you are. But
yes, I am.
If you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My rule. Okay. Thank you both.